Sad as it is to say, some green card interviews are turning into detention traps. People walk into a government building expecting a routine conversation, and they walk out surrounded by officers, placed in handcuffs, and transferred to an ICE holding area. Others are not arrested on the spot, but they receive a notice that sends their case to court, and they are picked up later. Either way, the fear is real, because detention can last days, weeks, or longer, and it can separate families, interrupt jobs, and destroy a sense of safety. If you have an upcoming adjustment of status interview, or if your spouse, parent, or employee is preparing for one, you deserve a clear explanation of what is happening and how to reduce risk. In this video, I will explain why interviews are becoming higher stakes, what specific facts are triggering referrals, and what practical steps you can take before the appointment. I will also explain why this is showing up in both marriage cases and employment cases, even when the person has no criminal record and believes they did everything correctly. The goal is not panic. The goal is preparation. When you understand the patterns, you can gather the right documents, correct problems early, and walk into the interview with a plan instead of hope. Stay with me because the details matter, and small mistakes are often the ones that create the biggest consequences. That is why we will cover the triggers, the timeline, and options. Welcome back to US Policy Brief. I am Michael, and I cover policy changes that affect immigrants and their families in the United States. Today we are focusing on adjustment of status interviews, often called green card interviews, and the reports of people being detained when an interview ends badly. Detention does not happen in every office, and many interviews still end with approval. But the trend matters because it changes how you should prepare. In-person interviews were reduced for a period, then returned, and now many USCIS field offices schedule interviews for cases that once would have been approved without one. Employment applicants, who historically had very short interviews, are now questioned for much longer. Family applicants, who once expected a marriage-focused conversation, may face deeper questions about prior immigration history and prior entries. USCIS has also been issuing more notices to appear in immigration court when an application is denied and the applicant appears removable. That creates a pathway where a single interview can start an enforcement process. Information sharing has expanded too. Records from taxes, prior visa filings, border travel, and databases are easier to cross-check, and officers are trained to look for inconsistencies. So even if you believe your case is simple, the officer may treat the interview as a full audit of your timeline. This video is educational, not legal advice, and it cannot replace an attorney who can review your documents. Use it to ask questions and prepare earlier than usual. First, understand how much harder employment-based interviews have become. Officers now treat many employment cases as a deep review of eligibility, not a quick identity check. If your green card is tied to an employer, they may ask detailed questions about your job title, daily duties, work location, remote work, salary, supervisor, and whether you are still working in the offered position. They may compare your answers to the labor certification, the immigrant petition, and your prior non-immigrant filings. They also review your entire immigration history to find gaps. They test whether the job offer is real. A common trigger is unauthorized employment. People assume that small side work does not matter, but an officer may view any work outside your authorization as a violation. Contract work, cash work, rideshare driving, or helping a family business can create issues, especially if it appears on tax records. Another trigger is inconsistent statements across forms. Something you wrote years ago on a student application or a work visa petition can be compared to what you say now. Even an honest mistake can look like misrepresentation when the officer sees conflicting dates or employers. If the officer believes the case is not approvable, they can issue a request for evidence, schedule a second interview, or deny the application. In the worst situations, they may decide you are removable because your status was violated and there is no protection. Some applicants can forgive limited violations, but that must be planned with counsel. Second, officers are expanding background and affiliation questions. That can include organizations you joined, causes you supported, places you lived, and online activity that is visible. Most people have nothing to hide, but the risk comes from incomplete answers, misunderstandings, and old information that was never disclosed on earlier forms. Third, there are specific red flags that repeatedly show up in cases that end with a referral. One of the biggest is prior contact with law enforcement. Even if charges were dropped or you were never convicted, an officer may ask for certified court records and police reports, and an unclear answer can cause delays. Another red flag is a prior visa overstay or any time you were out of status. Officers often ask for dates of entry, departure, school attendance, and employment authorization. They also look at travel under advanced parole and whether you returned properly. If you left and re-entered incorrectly, that can create technical problems that an officer may treat as serious. They also look for misrepresentation, meaning false or misleading information on any application, including old forms you did not personally prepare. A simple error in a birth date, marital status, address, or employment history can become an accusation if it appears intentional. Finally, officers may ask about prior immigration violations, removals, or border incidents, including expedited removal. Any of these issues can turn an interview into an investigation. That is why the best preparation is to know your record better than the officer does today. Fourth, many applicants are surprised by how much enforcement authority USCIS can exercise inside the interview process. Officers can stop an interview, separate spouses, ask confrontational questions, and require additional evidence on the spot. In employment cases, they can request updated employer letters, pay stubs, and proof you are still working. And they can order follow-up verification after the interview. Some offices also conduct workplace checks or contact employers to confirm job details. Fifth, the relationship between USCIS and ICE can matter. USCIS is not ICE, but when an officer believes someone is removable or believes fraud is involved, the officer can refer the case and coordinate with enforcement. In some reported situations, ICE agents wait nearby and respond if called. That is why an interview that feels like a denial can become a custody event. The moment of highest risk is usually at the end, when the officer decides the application cannot be approved and the applicant has no other lawful status to fall back on. If the officer concludes you are out of status, worked without authorization, or made a misrepresentation, the officer may issue paperwork that places you into removal proceedings. Sometimes that is only a court notice, but sometimes it leads to detention, especially if there is a prior order, a criminal issue, or another factor that makes enforcement immediate. The key takeaway is that you should treat the interview like a legal proceeding. Preparation, honesty, and consistency are not optional. They are safety measures. Sixth, detention risk increases when your adjustment application is deemed not approvable. Many applicants do not realize that the application itself does not automatically protect you if the officer decides you were never eligible to file, or if you became ineligible and have no valid status. If the officer denies the application, USCIS may issue a notice to appear, which starts removal proceedings in immigration court. In some places, the court notice is mailed later, but in other situations, the person is taken into custody, especially when the officer believes there is flight risk, prior removal history, or evidence of fraud. That is why maintaining a backup status can be critical. If you can lawfully keep a student status, work status, or another classification while the adjustment case is pending, you may have more options if something goes wrong. This is not always possible, and sometimes the adjustment filing changes what you can do, so you need individualized advice. But the concept is important. Do not rely on one filing to hold your life together if your facts are complicated. Also remember that some denials are preventable. Applicants are denied because they cannot prove lawful presence, cannot prove a qualifying relationship, cannot prove the job offer still exists, or cannot produce required documents at the right time. Those are preparation problems. When you identify weaknesses before the interview, you can often fix them with evidence, explanations, or legal arguments, rather than facing them for the first time under pressure. Seventh, family cases are not automatically safe. Marriage-based adjustment interviews can still trigger detention when officers suspect fraud, when there is a prior removal order, or when the applicant has serious status violations that are not forgiven in that situation. Officers may separate spouses, compare answers, and look for evidence that the relationship is real. They may ask about addresses, finances, children, prior marriages, and the story of how you met. That part is expected, but what surprises people is how quickly the interview can shift to the applicant's immigration history. If you overstayed a prior visa, worked without authorization, entered with an intent that conflicts with what you told the border officer, or had prior petitions filed for you, those facts can come up. Many people have heard that overstays are forgiven for immediate relatives of United States citizens, and often that is true. But it is not a free pass for every issue. Misrepresentation, false claims to citizenship, and certain criminal issues can still bar adjustment. Another high-risk situation is entry under ESTA. If someone entered under ESTA, overstayed, and then files through marriage, the case can be more fragile because removal can move faster and there may be fewer procedural protections. Also, local practices vary. One office may handle a borderline case with a request for evidence, while another may deny and refer. So do not assume that someone else's experience will match yours. Prepare as if your office will be strict. Every detail matters. Eighth, let's focus on what you can do before the interview to reduce risk. Start by building your timeline. Write down every entry to the United States, every exit, every visa status you held, and every employer or school. Then compare it to your filed forms, your passport stamps, your I-94 records, and your tax filings. If you see a gap, do not guess, investigate it. If you were ever arrested, request certified final court dispositions before the interview, even if the case was dismissed. If you had prior immigration filings that you did not keep, consider requesting your records through a formal file request so you know what USCIS sees. For employment cases, collect updated job letters, pay stubs, and proof of the offered position, and confirm that your job duties match what was promised in the petition. For marriage cases, bring strong evidence of a shared life, including leases, bank statements, insurance, and photographs, but also be prepared to explain prior marriages, prior petitions, or complicated timelines. If English is not comfortable, request an interpreter through the proper procedure, and do not rely on a friend to translate unless allowed. Most importantly, talk to a qualified immigration attorney if you have any red flag. The interview is not the place to discover a problem you could have solved months earlier. A good legal review can identify risks, prepare a strategy, and decide whether rescheduling or withdrawing is safer than walking into a trap for you and family. On the day of the interview, your behavior and your answers matter as much as your documents. Arrive early, dress professionally, and bring organized copies of everything you submitted and everything you plan to show. If you have an attorney, have the attorney attend with you whenever permitted, because counsel can intervene if questions become confusing or unfair. Listen carefully, answer only what is asked, and never invent a date or a detail to fill silence. If you do not remember, say you do not remember, and offer to provide documentation later. If you do not understand a question, ask the officer to repeat it or rephrase it. If you need an interpreter, Do not try to push through and hope for the best. Misunderstandings are a common source of inconsistencies. If the officer raises an accusation, such as unauthorized work or a false statement, do not argue emotionally. Stay calm and ask what document the officer is relying on. Sometimes the issue is a misunderstanding that can be clarified with records. Finally, have an emergency plan. Tell a trusted person where you will be and when you expect to finish. Bring contact information for your lawyer and have funds available in case legal action is needed. If you are detained, do not sign documents you do not understand. Do not discuss your case with strangers and request to speak with your attorney. Detention is frightening, but preparation can shorten the chaos and protect your rights while your lawyer works. Let's recap the main message. Green card interviews are higher stakes because USCIS is conducting more in-person interviews, asking deeper questions, and cross-checking information across many databases. Employment-based cases face long interviews focused on job details, tax records, and unauthorized work. Family-based cases face intense scrutiny of relationship evidence and sudden shifts into immigration history, especially where there are overstays, misrepresentation concerns, or prior orders. Officers also have tools to issue a notice to appear, and when they believe a person is removable, they may coordinate with ICE, which is why a failed interview can sometimes end in detention. None of this means you should cancel your interview or live in fear. It means you should prepare like it matters, because it does. Build your timeline, collect certified records, match your answers to your filings, and get legal advice early if any red flag exists. If you learned something useful today, subscribe to US Policy Brief so you can stay informed about policy shifts that affect your case. Share this video with a friend who has an interview coming up, because one conversation can prevent a disaster. As always, this content is general information, not legal advice, and outcomes depend on your facts and your local office. If you need personalized help, consult a qualified immigration attorney. Keep your documents organized, your answers consistent, and do not face this alone. Thank you for watching. I am Michael, and I will see you in the next video.